Hi everyone, I'm Caroline Sakarian and I work for the Office of Civics and Community Services here at the Los Angeles Public Library. Welcome to our Know Your Housing Rights series. Today's program is called Know Your Rights, Tenant Basics, and is brought to you by the Housing and Economic Rights Advocates and the Los Angeles Public Library. Today, Xinyi Zhang from HERA will cover everything from lease agreements to eviction procedures. He will also talk about how to navigate Los Angeles specific laws like the Rent Stabilization Ordinance and the California Tenant Protection Act, ensuring that you are equipped to handle disputes, rent increases, and maintain a fair landlord-tenant relationship. We will have a brief Q&A after the presentation, so please send us your questions throughout the program. Thank you and take it away, Xinyi.
Hi, thank you, Caroline. My name is Xinyi Zhang. I am with the Housing and Economic Rights Advocates. We are a nonprofit based in California, dealing with economic empowerment and issues such as tenants' rights and home ownership throughout the state, along with numerous other issues that we handle for the residents of California. Today's presentation is going to be about basic tenants' rights. The purpose of this presentation is to provide you with general knowledge about basic tenants' rights in California. Feel free to post any questions you have. However, if you, I'm going to forewarn that if there are any very case-specific questions involving your personal circumstance, I would direct you to reach out to us at HERA directly so that we can give your case the proper attention. The one, just because we're going to be dealing with some general concepts here. We're not going to get too much into the weeds because the law in this area can get very complicated very quickly based on the facts. And also because of confidentiality reasons, you may not necessarily want to share deep personal matters on this online venue. So without further ado, let's get started. We are talking about basic tenants' rights here in the state of California. This is what our agenda is going to look like today. We're going to just cover this basic outline. Number one, landlord obligations. Number two, tenant obligations. Then followed by basic tenant rights, tenancy relationships and rights, applying for housing, vacating the unit, certain fair housing laws, and any additional tenant resources, followed by questions. This presentation is designed so that we're going to go into a little more detail on topics that we encounter most frequently. And for other topics, you may find that we're taking a very top-down general approach, just because the time constraints that we have for this presentation. Okay, so we're going to get started here. Now, landlord obligations. Now, state and local laws, they impose certain obligations and duties upon a landlord. These are obligations that they have to fulfill in order to abide by the law as a lawful landlord. These include complying with anti-discrimination laws. In general, landlords are not allowed to discriminate based on any kind of protected class, such as race, sexual orientation, um, so on and so forth. Landlords are obligated to follow state and local laws when it comes to setting and collecting rent, when it comes to handling utility payments and security deposits. They are obligated to provide habitable housing. We're going to get into some of the definitions of what that means. They are also obligated to provide and comply with legal lease agreements that they draw up and they enter into with tenants. They have to make legally required disclosures. They have to respect tenant privacy, and they have to follow state and local laws when it comes to ending a tenancy and evicting a tenant. Now, also, they are not allowed to retaliate against any tenant who decides to exercise their own legal rights. And we're going to get into that topic as well, okay? On the flip side of that, tenants also have obligations of their own. Now, as a tenant, certain obligations that you have to follow in order to be on good legal footing. The first and biggest one is paying rent. This is the most basic tenant obligation. Number two, complying with the lease agreement, the agreement that you enter into in writing with the landlord, that is usually binding in a lot of cases when disputes show up. If you have a case that arrives at court, most of the time, what is written in the lease agreement, as long as that's legal, is what is going to decide which way the case is going to go. You are obligated to keep the unit clean and sanitary, and you are obligated to properly use and operate the fixtures. We're going to kind of touch on what types of behaviors are outside of that, improper use or damaging fixtures, for example. Also, occupying the premises as it was designed and using it for its intended use. Okay, so those are the basic tenant obligations. Here are the basic tenant rights in California. These are the rights that tenants enjoy. And in California, tenant rights are, for the most part, pretty robust. If you compare tenants' rights in California to other states, such as neighboring Nevada, you'll find that California residents enjoy quite robust protections, which is great. But still, problems always pop up when dealing with landlords or whenever there's disputes. So we want to be aware of our rights, which is the purpose of this presentation. Basic tenant right is habitability. Habitability. The unit has to be in a habitable condition. It has to be clean. It has to be a place where tenants can live comfortably. There are limitations on landlord entry that we're going to talk about. Very specific procedures that a landlord has to follow when handling security deposits. Also, tenants are entitled to a right to notice. When facing things like eviction, for instance, you are entitled to a certain amount of proper notice before you can be evicted. And we're also going to touch on limited statewide good cause evictions and also certain rent controls that may apply to your area. And I think we're going to get into these in more detail right away, because these are the most basic foundations. These are the number one questions that we get whenever we have a client come to us with tenant issues. So this is our bread and butter. Okay, so this is going to be maybe the majority of what we get in terms of cases. So the biggest tenant right, habitability. Let's dive into this a bit more. Tenants have the right to live in a habitable residence. Landlords are legally required to provide habitable rental units. What does that mean? What does habitable mean? In a very general sense, it means fit for human occupation. Of course, more specifically, that means a unit has to be free of certain harmful substances. The big ones are mold, asbestos, lead. They have to have safe and intact structural elements. They have to have, for instance, stairs, walls, roofing, plumbing, and electrical, all in good working condition. Um, Landlords have to provide heating and hot and cold water. The conditions of the units, they have to be sanitary, they have to be clean. This involves the landlords being responsible and helping with pest control issues. And also, landlords have to take reasonable measures to protect the safety on the public areas of the property, preventing break-ins, monitoring for criminal activity on the property. And we'll get into a little more detail on that as well. As a tenant, how do you go about addressing habitability issues? The biggest thing, and this not only applies for this particular issue, but I want you guys to start noticing a trend throughout this presentation, that it is very, very important to document everything, okay? 9 times out of 10, anytime there's a dispute, if it reaches court, if lawyers get involved, we want to avoid that at all costs, because that's very expensive and time consuming. But life is not perfect, and sometimes that's the route that we have to take. But any time that that's where the case is headed. The party with the better documentation is going to be in a stronger position. Okay. So document everything, make sure it is organized, make sure it is legible. You don't want to ever show up to court with a huge binder full of loose papers with just random notes scribbled in. You want it to look like something that you could just easily present to a judge and have them just glance at it and be able to see what you're trying to get at. Okay, so document everything with times, date stamps. Um, when you make a repair request to your landlord about habitability issues, make sure they are in writing. Make sure that is filed away. If the landlord does not fix issues, there can be other options that you can call upon, such as reporting them to code enforcement. You can repair and deduct from your rent, although I'll touch on that in a little bit here. We want to be careful when touching the rent, okay? There can be health department complaints that we can lodge, withholding rent, small claims court for costs of repairs that you had to make yourself. Um, Now, I mentioned we want to be very careful when it comes to any kind of withholding of rent or deducting from rent. Okay. Usually, we caution clients not to pursue that, not to withhold rent. It's a The law technically allows for that in some very specific instances. For instance, if a landlord is not making necessary repairs to make a unit habitable, you do have the right to uh, do the repairs yourself and then deduct that exact amount from the rent. Okay. But the procedure, most clients find that it's very specific and they may bungle it. Okay. For instance, you have to hire someone that meets certain professional standards in the state of California. You have to deduct the exact right amount. And the same goes for withholding rent. You have to hold that for the sole purpose of effectuating repairs to your unit. There's very specific laws that come into play when you choose to deduct rent or withhold rent. And if you mess it up, the landlord then has a cause of action to go after you for the rent that you owe. Okay. So although that is a legal right, we always want to kind of put an asterisk next to that and caution clients not, before they do that, think very carefully, because it's easy to kind of run afoul of the specifics, and you want to be very careful before you do that. Okay. Now, moving on, depending on the extent of the habitability problem, a landlord may be required to relocate a tenant temporarily, for instance, to a motel or a hotel while the unit is being repaired. And they have to cover those costs, okay, for relocation. And we get that quite often. We get tenants who have to relocate due to severe mold issue in their unit, and the landlord is obligated to pay for hotel costs as they're making those repairs to the unit. Okay. We're going to move on to the next tenant right. This is the next big one that we hear a lot: limitations on landlord entry. We get clients all the time who complain landlords just barge in. They're not allowed to do that. In general, landlords have to give reasonable written notice to the tenant in order to enter a unit. That usually is 24 hours. And they have to specify what they're doing. They have to be able to point out they're making agreed upon repairs, or they're showing the unit to a prospective renter if you're in the process of moving out, or if they're doing a pre-move out walkthrough inspection to make sure, just to assess the damages to the unit so that they know what kind of repairs are necessary and possible deductions to your security deposit. Those are valid reasons, and they have to give a valid reason. In very limited circumstances, landlords can enter a unit without giving any notice, and that usually falls under the category of emergencies. Flood, fire, if they hear someone calling for help in the unit, something like that, an emergency. Okay. Um, Other than that, they can usually obtain entry by getting a court order, or if they have determined that the tenant has abandoned the unit, or if the tenant provides consent to entry, then these are the incidences, circumstances where they can't enter a unit without prior notice. Any excessive attempts by a landlord to enter the unit could rise to the level of harassment, retaliation, and/or discrimination. Security deposits. Very common issue, again, that comes up whenever you have to move. The limitations on the amount of security deposit they can request as governed by the state. For unfurnished units, it's usually capped at 2 times the monthly rent. For furnished units, it's usually capped at 3 times the monthly rent. What they're able to deduct from your security deposit when you move out: damages beyond normal wear and tear. So if a tenant is particularly destructive and they cause a lot of damages to the unit, that is when the landlord can go ahead and deduct. Also, the cost to clean the unit to make it as clean as when the tenant first moved in. And also, they can deduct from the security deposit to cover for unjustified unpaid rent. And because, again, documentation is important. That's why a lot of times when you move into a unit, the landlord is going to hand you a survey, one of those forms where they ask you to go through the unit, inspect it, and fill in whatever you notice is damaged. That's documentation for later on if they have to deduct from the security deposit. That's documentation that both parties have that says, hey, this is the condition of the unit when you first moved in. If it's been damaged since then, we're in the right to deduct from your security deposit. All right. So once again, documentation coming into play. If there are none of these damages that we have listed, none of these allowable deductions, then the landlord has to return the full or the deducted portion of the security deposit to the tenant within 21 days after the tenant moves out. And if a landlord deducts any portion of the security deposit, then the landlord has to provide the tenant with a certain number of things. Any remaining refunds, a written letter explaining the deductions. Usually that's an itemized list laying out what each item was. Here was the damage to this room. This is what it cost to repair, and this is the reason for it. The next item, itemized list of deductions. Copies of receipts unless repairs cost less than $126 or the tenant agrees that the landlord doesn't need to provide those receipts. Basically, they need to provide an accounting of why they did the deductions from your security deposit. Next right is the right to provide the tenant with written notice. The landlord has to provide the tenant with written notice in order to evict for any reason. Most of the time, what you'll receive is not immediately an eviction notice, but it's something that is a cure or quit notice. For instance, it'll say tenants have a cure period for a violation such as non-payment of rent. And that comes before the landlord goes ahead and files an eviction lawsuit and serves the tenant. If the violation is egregious, for instance, if a tenant has caused a ton of damage to the property, severe damage, or they've conducted any kind of criminal activity on the premises, then a cure period isn't necessarily required, and they may move straight ahead to eviction without the opportunity to fix the issue. Now, as for the actual notice to evict, certain time periods will apply depending on your circumstance. If a tenant's been living in the unit for 30 days, then the landlord has to provide the tenant with at least 30 days of written notice. If the tenant has been living in a unit for more than a year, then a landlord typically has to give 60 days of written notice. In most cases, a landlord can't terminate a lease without cause before the end of the lease term. The lease will usually change to a month-to-month tenancy unless the landlord and tenant agree to renew for the initial lease term. And the end of the lease does not constitute just cause, okay? So in California, what you'll find, and I'm sure most people have encountered this, you'll start off with a year-long lease. That's usually the typical time period. And after that year, it becomes a month-to-month tenancy. Okay. Um, so that's what they're talking about here. Moving on. Now, in California, there's further protections that a tenant should be aware of. For instance, the Tenant Protection Act. This act, which is governed by Civil Code 1946.2, states that evictions can occur in certain circumstances. One of these is something known as no fault just cause eviction. This is a circumstance where a tenant has not violated the lease in any way, they've not done anything wrong, yet the landlord, under these specific circumstances, can still go ahead and proceed with an eviction. That's why they call it no fault just cause. Um, and typically, what this is when an owner's family member or the owner himself decides they want to move into that unit. Um, Also, another circumstance, they intend to demolish the unit or substantially remodel the unit, or if they withdraw the unit from the rental market. Um, so they, although the landlord may be required to pay for any kind of limited relocation assistance for the tenant when this happens, these are circumstances where the landlord can go ahead and proceed with an eviction, even if there's nothing wrong, that the tenant has done nothing wrong. Okay. Um, Another set of circumstances that is tied to the TPA is called at fault just cause. This is where the tenant has violated a material term of the lease or engaged in some kind of specific actions. The big one is non-payment of rent, any kind of criminal activity on the premises, refusal to allow the landlord to enter the unit, even if they have a lawful, they've given lawful notice and have a lawful reason. These are circumstances where the eviction can go forward and the tenant is at fault. Um, Now, these protections under the Tenant Protection Act apply only to certain tenants. They don't apply to everyone. Okay. Now, here, the following are the exceptions. Um, Although there's more that aren't included in this list. Here are the big ones. Um, they don't the TPA does not cover transient and tourist hotels. They don't cover housing in nonprofit hospital, religious facilities, extended care facilities. They don't cover housing for student dorms, a duplex where the landlord lives on the property, units built within the last 15 years, a single family home not occupied by a corporation, a real estate investment trust, or an LLC with one or more corporate members, uh, or when tenant shares the bathroom and the kitchen with the landlord. So typically, what does that look like on the day to day for us? When it's usually, it does, the rule of thumb is the TPA doesn't apply to newer units and for mom and pop landlords. Okay. So if you have a mom and pop landlord, these types of protections usually aren't going to benefit the tenant. Um, Also, there are statewide rent control ordinances that can help out tenants. Generally, a landlord's raising of the rent is capped at 5%, or plus the CPI or the 10%, whichever is lower. The CPI, that's one of those concepts that we're not going to get too deep into, but it generally what that deals with is inflation. Okay, so 5% plus um, the certain CPI index dealing with inflation, or 10%, whichever is lower. Um, and the law does not apply to all units. And keep in mind, there are local rent control units in certain jurisdictions that may apply instead of the state laws. We're going to get into Los Angeles. That's one of those jurisdictions with more protective local rent control laws. I believe they cap it at 4% up until a certain date. Um, we're going to move on to the next set of facts here. So these are circumstances that you'll often find when talking about tenant-landlord relationships. One set of circumstances is if there are two tenants in a unit. The landlord, what that means is the landlord has a lease with each of them, and the landlord can enforce that lease upon each of them. We're going to talk about a different set of facts in a little more detail, and that's when there's a subtenant. That is when there is a sublease signed between the subtenant and the master tenant. And the difference between these two circumstances is who the landlord can really go after, who's on the hook when something goes wrong. When there is a co-tenant and another tenant, the landlord, those two tenants, depending on who did wrong, they can be each on the hook to the landlord. When there's a situation with a master tenant and a subtenant, then the person on the hook is the master tenant. Okay, so they're going to be held liable for anything that the subtenant did wrong, and we're gonna kind of dive a little more into that. Under California law, the landlord may be able to refuse to allow a tenant to sublet their unit if and only if the lease clearly and explicitly prohibits it. If the lease requires that a landlord's permission to sublet is a necessary component, then they can't unreasonably withhold that consent. The original tenant remains responsible for the terms of the lease, like we discussed. The master tenant is the one that's on the hook if anything goes wrong. The master tenant is responsible for paying rent to the landlord for all the tenants. They may collect the rent from the subtenants. The subtenant doesn't pay the landlord directly usually. The master tenant is there to ensure that the subtenants follow the lease terms. The master tenant could face liability for any violations made by the subtenants. And they usually have a separate agreement with the subtenant called the sublease. But they have to enforce all the agreements in the master tenant's lease with the landlord. So they can't override something that they agree to in the master lease with their subtenant. The master tenant has the authority to evict subtenants, but they have to follow all the same local, state, federal laws that the landlord has to follow, and also retaliation is prohibited. So they have the same protections. If the subtenant has committed violence against the main tenant or any other subtenants, then the correct measure for the master tenant would be to call the police, consider any kind of civil harassment, restraining order against the subtenant. Similar measures that a landlord would have to take against a master tenant. As described earlier, the master tenant is basically like the landlord to the subtenant, which is why the subtenant should read the master lease before signing the sublease to make sure that the master lease doesn't prohibit subletting and that the subtenant and the master tenant are paying a fair share of the rent. They can go ahead and sign the sublease agreement with the master tenant with that understanding. And the reason for reading that master lease, if you're the subtenant, you don't want there to be any guarantees or assurances in your sublease that aren't allowed in that master lease, because that master lease is what's going to carry the day. In most cases of just cause eviction protections apply to the property, they would also apply to the subtenant. And the master tenant must follow the same laws as the landlord when they go ahead and try to evict the subtenant, notice requirements, just cause, et cetera, et cetera. Here are some tips that we provide to our clients when it comes to applying for housing. And these are some of the laws that you want to be aware of when you're going through this process. You want to go ahead and inspect a rental unit before you rent. Again, this not only deals with making sure that this is the kind of place that you want to live in, but remember the documentation component of all of this. The condition of the apartment when you enter it, that is kind of the baseline that is going to apply when you're talking about deductions to your security deposit when you move out. So anything that's wrong with the unit, any kind of damages, you want to make sure that that is documented and distributed to both sides, both parties. That way, there is no misunderstandings about, hey, who caused this damage to the unit, etc. Application fees, a landlord cannot charge more than the price set under California law for an application screening fee, which is usually around $59, dependent on, again, that consumer price index, which is the dealing with inflation. Applicants have a right to copies of all the reports that a landlord uses to make their decision about whether or not to accept this tenant. If a landlord denies the rental application, at least based partially on your credit score or any kind of tenant screening report, then the landlord needs to provide you with a letter stating certain things. They need to state that the denial was based, on the credit or screening report, the name, address, and phone number of the reporting agency. And they also have to state that you have the right to obtain a free copy of the credit report from that agency, and if necessary, to dispute the accuracy and completeness of the information in that credit report. When vacating a unit, be sure to provide notice to your landlord in writing. Generally, notice should be given for the same amount of time as there are days between rental payments. So, for instance, if you pay rent every 30 days or the end of the month, then that's typically what you want to give in terms of notice. You want to give 30 days notice. For evictions, a landlord has to give a tenant proper notice to vacate, and they have to comply with state and local laws. This is going back to what we talked about in terms of proper notice. Um, Tenants who are victims of crimes, for instance, domestic violence, sexual assault, stalking, human trafficking, elder abuse, violent crimes. There may be circumstances where they get to terminate their tenancy before the lease is up, even, and this is protection provided by California Civil Code 1946.7. The most common circumstance that we see where that comes up is usually in domestic violence circumstances. For instance, if a victim has filed a restraining order on someone, and they wish to vacate the unit because they feel like their life is in danger, that is usually the most classic case where someone gets to terminate their tenancy without any repercussions. Also, another set of protections that California tenants usually apply falls under the Federal Fair Housing Act, also California's Fair Employment and Housing Act, and the Civil Rights Act that protects tenants from discrimination. And the most relevant portions of those acts we've included here. Tenants are protected from discrimination in the rental process while they are tenants. It is unlawful for a landlord, an agent, a broker, a salesperson, representative, basically any agent under official capacity to the landlord, to discriminate against anybody because of their race, color, religion, sex, military status, income, disability, and numerous other conditions. They're not allowed to discriminate based on any of those factors. Tenants with disabilities, they're entitled to make reasonable accommodation requests to rental units that are necessary to allow a tenant to fully use and enjoy the unit. And if a landlord refuses to make any kind of reasonable accommodation requests, then that could fall under discrimination rules and practices that are not allowed under the state or federal laws. Filing for fair housing complaints. When you're making a fair housing complaint under federal or state law, the discrimination has to be linked to a certain protected status. For instance, refusing to rent to a family because they have young children, that is a discrimination due to familial status. So that's a protected status. So the venues where you could make fair housing complaints, number one would be the California Civil Rights Department. You can either make a complaint online, over the phone, or via mail. These complaints usually have to be filed within 1 year of the date of the harm, and the website is provided on the slide there. Also, the U.S. Department of Housing and Urban Development. You can make complaints online, over the phone, or via mail. And this HUD investigates complaints in private and public housing, and in most cases, you have to file the complaint within 1 year of the date that the harm took place. Their website's provided there. Another avenue for potentially claiming damages is small claims court. Small claims court is usually the venue that clients go to when they're trying to seek monetary damages from a landlord. Small claims court is, depending on the jurisdiction of the court that's set up, in general, they're very fast. They're relatively friendly towards lay people, the lay person without an attorney. Many small claims courts, their cases, they don't have attorneys representing the clients. It's tenants and landlords who show up, and a judge or commissioner makes the decision based on the facts of the case. And it usually moves very quickly. Again, the damages are capped at $10,000, but it's designed for most cases there where the damages fall under that cap, where the court can kind of provide relief that is very quick, and usually it's not as complicated as something like a major civil lawsuit. It's something that we usually help our clients navigate relatively easily, just providing them information on how it's done. But that's a very common avenue that clients usually go through. Civil lawsuits. This is a much more complicated issue. There's no limitation to the damages, but it is extremely hard to file a successful civil lawsuit without private counsel being involved. We have a lot of clients who have grievances, who wish to sue their landlords, and usually we have to kind of tell them the realities of what that means when it comes to filing a civil lawsuit. Anytime private counsel gets involved, it's usually a very expensive, very time-consuming process, which is why these types of lawsuits should be limited to cases where there's some kind of catastrophic damages, large dollar amounts, very serious monetary issues that would interest a private counsel. For instance, if sometimes we get cases where if there's a habitability issue in a unit and it caused long-term medical conditions in a client, and that resulted in many thousands of dollars of lifelong damages, that would be an appropriate case for the private counsel. Your typical dispute with a landlord, which doesn't involve a set of facts that serious, would usually be sent to small claims court. So just something to be aware of. Not to say that anyone's issues are not serious or less serious, but we're talking about dollar amounts and hiring private counsel who want to be paid for their time and their work. We're talking about economic realities, really. That's the main thing that kind of separates these two. Yeah, so that's something that we want our clients to be aware of as well. So those are the basic, it's a basic outline of tenant rights in the state of California. And remember that what we talked about is that this is the presentation is designed to give a general overview of the laws. If you have any specific um, case fact intensive questions, we urge you to contact our office specifically and make an appointment so that we can go ahead and delve into the facts of your case and provide you with the best tailored answer. But hopefully this was enough to be helpful so that you have a general framework with which you can kind of see where your issues fall. Okay. Um, for additional resources, we urge you to contact, first of all, our office if you have any case that you would like to talk about. Another great resource is the Legal Aid Foundation of Los Angeles, and also Public Counsel. These are great nonprofits in the LA area. I've personally worked at both earlier in my career. Another one is the Alliance for Californians of Community Empowerment, and the Tenants Together, which is a statewide organization. Those are the additional resources that you should pursue if you have extra questions. And I'll turn it over to Caroline.
Thank you so much, Shini, for a great presentation. Let's get to the questions. So let's see. How would someone go about proving retaliation by a landlord?
Um, First and foremost, remember what we talked about in this presentation. If there's one thing I want everybody to take away from, not just when it comes to tenant issues, but this could help you in any legal issue, okay? The number one thing I want everyone to take away from this presentation is document, document, document.
Hmm.
Um, the num the when it comes to court, when it comes to even negotiations with the other side, the party that has the most clear and precise documentation is usually at the advantage. So anytime there is retaliation by the landlord against you, you should have a log of that. Try to communicate with the landlord via email if possible. That way it's just a clear format where everything is timed and dated and it's written, the communication going back and forth. It's just very clear evidence to provide. In California, though, there are laws put into place to help tenants in this issue. Um, if a tenant asserts their basic tenant rights and the landlord perform some type of negative action towards you within 180 days of your asserting your right, that is presumed by most California courts as retaliation. Okay, so that's a huge advantage that California tenants enjoy that most other states might not provide. So remember that 180 days, if they take some sort of negative action after you've asserted your tenant rights, for instance, if you make a complaint about habitability, if you make a complaint where the landlord is not providing reasonable accommodations for your disability and they don't take any action, and in fact, they try to evict you after, within that 180-day window, the standard rule is that the courts will presume that that is retaliation. Okay. Now, past that 180 days, that's where documentation is your salvation, right? That's really where the courts are going to be like, well, this is remote in time. Do you have something to prove that? That's where you want to bust out your notes, your emails, any recordings you have to kind of prove. That's where you have to kind of prove what happened. So uh, that's a long answer, but basic summary: within 180 days, it's presumed to be retaliation. Past that, you have to prove it. But in all cases, document, document, document. Okay.
Thank you so much. I didn't even know about the 180 days. Good to know. And yes, documentation is key. Let's see. We have another question. Are there any LA specific protections to rent increases? And what about for evictions?
So yeah, I touched upon this briefly in my presentation. The statewide general rent control is 5% of the the CPI, that price index, or 10%, whichever is higher. Um, LA has something that's a bit more protective. So LA's current rent control ordinance is 4%. Landlords are capped at 4% of rent increase per year. That protection only applies to June of this year. I want to say June of this year, 2024. Afterwards, the cap is raised slightly to about 4.25%. Okay. So LA is a bit more protective than the state. Currently 4%. After June of this year, something like 4.25%. That's what they're capped at. As far as LA specific protections for evictions, LA uses ordinances that are very, very similar to the TPA. So if we think back on the protections of the TPA, um, that's generally what it's going to look like in LA as well. And that is, you have a couple of broad fields where landlords can evict. One is the no fault eviction. That's where a tenant has done nothing wrong, but the landlord, under certain circumstances, can evict. For instance, if they want to move themselves in, move a family member into the unit, or they take the unit off the market as a rental, that's where they're allowed to go ahead and do that. And also this other big bubble, which is the at fault just cause eviction, where the tenant has done something wrong. They've violated a lease agreement, they've committed some kind of criminal activity. That's where they can go ahead and evict when the tenant's done something wrong. And keep in mind, these protections don't apply in certain circumstances. Usually, if it's a mom and pop landowner, nothing to do with a corporation, that's usually when these protections don't apply. So LA has something that's almost identical to that, I would say.
But so when you say LA, do you mean like LA County, right? Or is it city of LA?
I think it's the city of LA.
Oh, okay. So basically, like if you're in Los Angeles County, like one of the other smaller cities, let's just say like Pasadena or somewhere. So that's not like
I let
considered.
me rephrase. I mean LA County. LA
Yeah,
County.
that's what. Okay. Okay. So
I
it's like
apologize.
all of the county. Yeah. Cause I know we have I mean, it's a lot of LA City, but we have a lot of other, like some like Glendale and like other like Santa
Yeah.
Monica, those smaller cities. Okay. So perfect. So that's LA County. That's great to know. I didn't know of the 4%, then 4.25 June of this year, most likely
Mm-hmm.
June.
Mm-hmm. Yeah.
Okay.
June of
Perfect.
2024.
Okay. Sounds good. Thank you. Let's
Mm-hmm.
see if there's any other questions. Okay. I don't see any right now. So thank you so much, Shuni, for a great presentation again. I wanted to let everyone know if anyone missed any of this presentation, it is going to be available shortly on LAPL's YouTube channel. The URL is youtube.com/Los Angeles Library. And then we're very excited. Our next streaming program with Hera, it's next Monday, May 13th. It's called Estate Planning. We're going to have a Spanish version of that at the end of the month. So, for all information on this program and all of our streaming programs with Hera, the website is lapl.org/housing rights. So, thank you again, and everyone have a great rest of your day. Thank you so much. Bye,
Thank you.
everyone.
Take care. Bye bye.